a corporal. If they really valued his services to this country, they ought to have to promoted him to a level of sergeant, at least, if they so much care about him. That persuasion is for you to feel the emotion.
Only my senior, though he has never been promoted to senior counsel, is still attacking the victim. I'm appealing the victim to be protected by senior counsel.
But you brought the victim to court.
I'm only looking at promotional issues, career progression. I have no business in this matter. Neither is it an employment and labor relations court.
Your Honor, they brought the issue of the age. It is in the affidavit, and they don't want us to go there. But we can forgive Mr. Omari for that oversight. Your Honor, you have been persuaded that this matter was in Fuko, it was in this radio station, it was in that television station by my learned sister, Miss Njoroge, Miss Karaoke. Your Honor, the reason why the prosecution is very, very persuasive, or they would really to Article 4, Chapter 4 of the Constitution of Kenya. Cecil Miller declined to develop rules, and when an application was taken before him, he said that there are no rules to enforce what? Fundamental rights and freedom. That metaphor applies to Mr. Omari, Mr. Ashoka, and my good, as the defense, as they call themselves. Kindly do not consider that line of submissions, that there are serious offenses before you. In any case, the death which Mr. Omari is alluding to, that should the officer die within 1 day, 1 year, 1 day, the accused person would be charged with murder. That is speculative. And Mr. Omari, unfortunately, he did not say, God forbid. Maybe he subscribed to my own belief that God is not obliged to answer our own prayers. Thank you very much, Your Honor.
Yeah, Your Honor, I'll be very brief, noting that it's almost getting to... well, to the best of my knowledge, you addressed Article 244, Mr. Omari, for your information. He will be under the custody of the police, as defined by Article 244 of the Constitution. If then he is not safe with the police who have now assaulted him, my running friend, Mr. Okach, was asking us, where is he safe? I want to submit that safety is not determined by the status of the victim. Further, Your Honor, I want to address you on paragraph 8, clause E. The DPP states that the complainant, who is 57 years old, feels victimized on social media and requests to testify before the accused person is released. It has not been alleged that our client is responsible of those social media publications. And he has not disclosed the source of the said victimization, nor has he associated it with our client. We submit therefore, Your Honor, that there is no jurisprudential value in alleging that he needs to testify first, so that then you can consider granting our client bail. You know, if the alleged victim feels victimized, my learned friend Mr. Omari knows the existence of Section 4 of the Witness Protection Act. They have not taken advantage of that provision, so that, Your Honor, if it is true that he is threatened, then they can take the necessary actions to commit him to witness protection. You know, Section 4 provides, subsection 2, that without prejudice to the generality of subsection 1, the actions taken under subsection 1 may include, but not limited to, physical and physical and armed protection. That is what the law says. That you can have physical protection or you can even arm that particular witness. This is a police officer, fully armed. And therefore he qualifies under Section 4. And as such, Your Honor, I join issues with my learned friends' earlier submissions and urge you to disregard the submissions by the DPP. They are only meant to whip emotions. Disregard the submissions by my learned friend, Mr. Omari. They are not factual. They have no basis. And we remind Mr. Omari that the world did not take Kenya to Haiti. Kenya took itself to Haiti. And as such, there is no prevailing reason that may invite you to decline to grant bail. You know, the proposal for the pre-bail report, as proposed by counsel, has not been brought out through an affidavit. It's not an averment that is contained in the affidavit by the DPP. It's a creation of my learned friend, Mr. Omari. He had the advantage of meeting his client. He had the advantage of bringing up an affidavit, but he declined and refused to seize that moment. You know, it is not disputed that the accused person has a permanent place of abode. Actually, it has been confirmed by the DPP that he lives in his mother's house. It has been the tradition of this court to ask the accused person to provide 2 contact persons. The parents are well suited to make sure that the accused person shall not jump bail. They are here before this court, Your Honor. They are capable of standing surety to ensure that this accused person fights or have his day in court. Finally, Your Honor, whatever happens outside this court, the court is blind to those particular facts. The court is only alive to the pleadings before it and the submissions and the averments made by parties before the court. In matter of fact, Your Honor, if I would be dramatic, slightly dramatic,
Please don't.
the people of the Republic of Kenya in support of Ian for having fought corruption or alleged fight corruption. The bitterness is not with Ian, but with the issues happening in this country, among them the heavy taxations. And as such, Your Honor, we pray that you grant Ian bail. The public will vent its anger against the regime in its own way, and Mr. Ian has nothing to do with that. I invite Mr. Secha to make briefs.
Thank you, Your Honor. I will start, Your Honor, by introducing the accused person before you. He is a 19-year-old student of Sunshine School, currently a first-year student of civil and structural engineering at the Technical University of Kenya.